Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
So this is, let's see, 2402428 LT, RPM Metro Detroit. 2402428 LT, RPM Metro Detroit Agency versus Jenny Johnson and occupants.
Good afternoon, Judge Johnson. This is Attorney Charles Spagnola. My team number is 72366, and I'm standing in for the attorney of record on behalf of the plaintiff.
All right. Thank you, Mr. Spagnola. And is Jenny Johnson present?
Yes.
All right. And tell us your name.
Janine Johnson.
All right, Ms. Johnson, it looks like we're here today for a termination of tenancy matter.
Yes.
So basically what that means is that the landlord is looking to get the premises back, get possession of the premises. They're not per se at this point looking for rent. All right. And so let's see here. I will take a quick look and see what they're saying.
Can I say something?
Sure.
Which I just spoke to the lawyer and I told him I was willing to pay the mortgage. I was under the impression that it's the mortgage people house because it's a lien on the house. I don't even know if this is Brian's house at this point, because when I was paying, and I was paying faithfully, I got a notice in October of the house was in foreclosure. So yes, I got the digging, looking to see what my options was. And apparently, because really I was getting the house from his mom. His mom died in January of 2022. My husband died March 2022. So that's who we were in agreement with. But, Brian told me, he took over, and I believe that, had no problem till October came. October came, got the eviction notice. I mean, the pre-foreclosure, and that's now everything is going left. He want me out the house. He don't want me to pay nothing. At this point, I'm like, is the house really yours? Because I will pay the loan, which they told me I could. Anyone can pay it at this point. So I was asking for more time, and he want me gone now.
I'm trying to understand what is going on with, who is Brian, number one? Number two,
the son.
Number two, after that is, there was some kind of mortgage foreclosure, you believe? Is that what you're saying?
Yeah, I have the paper right here. You probably can't see it. It was posted on the door. So I got the digging. I'm sorry, you probably can't see it. I got the digging. I called the number, and I called today, and to their knowledge, she's still alive, which she's not, because it's a $36,855.14 lien on the house. So I asked them, could I pay it? They said they don't care who they get the money from.
They don't.
So I'm willing to pay it. I got 2 boys in college. I'm struggling. My husband was the breadwinner. I'm willing to pay that until at least Terry he only got a couple months and he graduated from college. That'd be a bill off of me. Then if I have to move, I'll move. But
well, let me say this, okay? Because we have two things going on.
I'm sorry.
You're saying you think there was a mortgage foreclosure of some type. You're not sure who owned the house. You don't know if this Brian person does or somebody else does.
Right. Citizen Bank said they own the house because they got the lien out until that's paid off. It's their house, basically.
Well, that might be a good defense to a termination of tenancy. If they don't own the home, then they might not be the ones to be able to evict you. But then you're saying you want to pay.
I'm saying like far as it's $489.18. That's to the mortgage people though, not to him.
Exactly. So you're not trying to pay the plaintiff because they're not looking for money. I don't know why the plaintiff wants you out, but if you paid the mortgage off, then it's free and clear for whoever owns it to do whatever.
And they give me more time.
Hold on a second.
Sorry.
Mrs. Fenton, I know you're standing in, but what do you know about any of this?
Well, thank you for bringing that point up about standing in. Judge, I'm reviewing the complaint, and I just would like to bring it to the court's attention, though. The attorney of record did file a supplemental complaint for money damages. It looks like there was rent charges outlined in the lease agreement of $2,885. But that aside, my understanding is, Your Honor, that this individual, Brian Mathis, is contracted with RPM Metro, who is the property management company, and they're the ones that the attorney of record is representing. A deed was provided. I'm not entirely sure why Ms. Johnson mentioned that she was dealing with or working with maybe Vivian Mathis, but there was a quitclaim deed that was recorded and it was executed in 2016. It looked like it was recorded in 2019, Your Honor, showing Brian Mathis as the owner. So it appears that the property was quitclaimed to Mr. Mathis, who is contracted with the property management company, who is executing requesting the termination of tenancy.
Okay, so let's say he's got some kind of quitclaim interest in the property. She's saying she doesn't know if he owns it because somebody else has an interest in the property now?
I'm sorry.
Can
I talk? You go. I'm sorry. Go.
I thought I heard that there was a foreclosure, and if I called Kevin Callahan, Your Honor, while you were going through your other cases. He didn't know anything of that. Now, I wouldn't necessarily disagree with Ms. Johnson if you're like, hey, there was a foreclosure. We know in Michigan you have a statutory right of redemption, but if she's going to make the defense that maybe he doesn't have standing to bring forth this eviction, I understand that, but we have no evidence of that at the moment.
Right, and that's why I need more information. I'm adjourning this. Ms. Johnson, you got to get me something that shows that there was this foreclosure that you're saying, because he might not have.
And it's on the internet too, but I can bring it. It's a letter. It was posted on the door.
But what we would need is some kind of, you might want to go up to Oakland County. Register to see if there was a sheriff's sale or anything like that went on. Just the posting is not probably going to be enough. That might show something might have been started, but we need to know how it ended. And so if you go to the county, you should be able to get some records that would show if there was a sheriff's sale, when it was, that would show us who got the property.
I know who got it because I talked to someone. Is Citizen Bank what is it? Lien? Equity. I'm sorry.
You knowing is one thing.
And showing.
We see evidence of it is another thing. Okay? That's what I'm trying to tell you to go. So don't fight me on it. Just go get it. And it's probably going to back up what you said. We're not saying you're lying. I certainly don't know, and neither does Mr. Spaniolo. We're trying to figure out if what you're saying is true so we can decide who, if anyone, currently does have the interest in the property. And
Okay,
if our or whoever they are does not have that interest now, then they wouldn't be able to bring this case.
okay,
But we need to see some documents, not just you saying you talked to them. The
gotcha.
documents should show that. And it should show the redemption period and all of that.
Okay.
Can you do a little bit more digging and research? Get up to
Oh,
the
yeah.
county registry?
I will.
Okay, you doing it? Okay.
I will.
So then we'll adjourn this to see. Let's see. Let's give her 2-3 weeks so she can get it up there. And Mrs. Spaniolo, you know what's going on. So if you're not coming back, can you relay that to whomever that's what we're adjourning for and that we're looking for that documentation?
Attorney Callahan, absolutely, Your Honor. I
Okay,
asked
and
you.
what day? What day was it? I'm sorry, I didn't hear the date.
Judge, I just ask if we don't go out over 2 weeks so I don't have to request an escrow. If you're inclined to give Ms. Johnson time.
I'm giving her some time because it's a good defense.
Yeah, I want some time, please.
Well, then if we're going to move past 2 weeks, I'm going to request a court or move for an escrow.
May 9th, because that's the only thing my clerk has.
Okay. Can I get an escrow order, Your Honor, please?
What is that? What is that? I don't know what that is. I'm sorry. Could you let me know what that is? Because I don't have an agreement with Brian. I have one with Vivian.
Well, the judge may want to explain it to you, Ms. Johnson.
Oh, okay. I'm sorry. I don't know what that is. I'm sorry. What is that?
I understand.
She's a good advocate for herself. All right. So what an escrow order is there's a court rule in the Michigan court that deals with landlord-tenant type of cases. The rule is 4.201. So you can look that up online if you wanted to. But it talks about, when possession of the property is at issue and plaintiff shows a clear need for protection, then the escrow order can be entered. Let's see. And let's see. And an escrow is just to kind of cover the plaintiff for any, loss of revenue or whatever it is that's happening while the case is being resolved. And let's see what number 4. And
it might be noteworthy to point out that the money would be with the court, Ms. Johnson, not with us. So the court would hold on to it until they dispose of the case.
Well, how much money? Like, what's the money?
Usually what happens, ma'am, listen to me, over here. Now, what usually happens is there's usually rent that's paid between, quote, the parties. And in this case, I don't know who the parties really are because you're saying you didn't have a rental agreement with this gentleman here. No. Who were you paying?
Which I have the receipt and I'll bring them. He had me put the money in his mom account. So I was paying Vivian. Hello, that's what I was paying Vivian. What happened was once I found out where went left was in October when I found out the house wasn't his, it was Citizen Bank. So I wasn't paying nobody. But from 2 years since she been dead, he had me continue putting the money in her account, which is Vivian Mathis. I have her checking account number and I have every last receipt and I'll bring it. Yeah.
Okay.
And he don't have no records of no lease agreement at all.
Yeah, how is the point of showing a clear need for protection in this case?
He had never been here. I never met him. He can be Brian, all I know.
Well, I thought she stated that she was paying somebody. She was paying it and putting it in Miss Mathis's account.
He told me that, yeah.
Okay, so I think it would be appropriate or a mere suggestion for the court that amount that was being deposited be the amount in the escrow order.
No, because after the fact, I found out the bank was only getting $489.18. That's why me and him was arguing. Then he wanted me to sign a lease, and I told him I wasn't signing it.
Okay,
and this happened in October. It's now March.
Wait, this is
So
too
she-
confusing. Ordinarily, I order escrow. I'm not sure who gets what because this
Thank
is a,
you.
this is a little comedy of errors and confusing
Well,
to me.
I just want, I mean, we still have the supplemental complaint in play and we can bring that at the next hearing.
What is that?
Ma'am, supplemental complaint means for money damages,
No,
unpaid rent, but
no.
that's there right now. I'm just not gonna order escrow because I'm not clear about who was paying who for what.
Thank you.
I'm just clear, and I'm not clear as to who even owns it. So
I
no
can bring you the
escrow right
receipts.
now. You're gonna bring me more than the receipts. You're gonna bring me the stuff that you put from up there at the county, right? Then you're gonna have a couple copies of it so that the court can see one and there can be one for the other side to look at too.
Okay.
Okay, so the
Okay.
next date is
May 9th, and is that in person and what time, please?
You say May 9th?
yes,
Okay.
in person.
Yes, in person. Okay. Will I get a letter too?
Man, we're gonna send a notice.
Okay.
What time?
1:30.
1:30.
Okay.
Thank you, Judge Johnson. Have a good afternoon.
We'll see you then. Good
Take
luck.
care.
Ms.
Stay safe,
Johnson.
everyone.
Thank you. I
So
can leave
that
now?
is- Yes, you may.
Okay. Have a good one.
All right, bye-bye.
Bye-bye.
This is case number 2402428 LT RPM Metro Detroit versus Gene Johnson and occupants. Anybody on this case here today?
But I don't know where he went.
Who's the he, the other lawyer? Okay, well, we can pass it for a minute. I don't see this one. Oops. Here we go.
Apologies, Your Honor, I just finished over hearing it. Take our choice.
No problem. There you go.
Do we call the case?
Yes, I did.
Kevin Callahan, P78273 on behalf of plaintiff.
Okay, Mr. Kelly. And Ms. Johnson, how would you like? Okay, and so we are here for, this is a landlord tenant termination of tenancy matter. We were here on the 11th. And let's see, there was someone sending in for Mr. Callahan at that time. Yeah. Story.
But we have a resolution,
Yeah.
so, yeah.
Okay, well, let's skip to that.
Okay.
Okay.
I had the pleasure of speaking with Ms. Johnson, and I think all the issues have been kind of cleared up.
Okay.
And we've agreed to a consent judgment, whereas a writ shall issue after the 20th of May. I don't know if Your Honor would like me to put this on the further orders. However, I have worked out a deal with Ms. Johnson that once she does vacate, if she vacates timely, she can contact my office. I would go ahead and set aside this judgment and dismiss the case to protect Ms. Johnson's rental history. Further, I would be dismissing the money judgment in this matter as well, just for possession.
So today you're just doing a possession judgment?
Correct, yes.
Okay. You said the writ date will be the 20th?
The 20th. End of the day.
Yeah, okay. Okay, so everything, that long story that I didn't have to read into the record, that's all cleared up, correct? All right, and so now you're entering into a consent judgment, which means that you're agreeing with your landlord that you will in fact move, and that you will do that by May the 20th, 2024.
Yeah.
And that they are not entering into any type of money judgment, which means they would not be able to collect any money. If they wanted to do that, they'd have to file a different case. All right. And if you move by that date of the 20th, Then they will move to set this judgment aside and dismiss the case. That way, if anybody were to check, they wouldn't see that you have a judgment against you. So in case you need to rent in the future or something like that. So is that your full understanding?
Yes.
All right. And you're entering into this agreement voluntarily, correct?
Yes.
Have any other questions about anything?
No.
All right, so you have 3 days from today's date to ask me to set aside this consent judgment. If there's something about the rights that you're giving up that you do not understand, or something about this judgment that you don't understand, set it aside, we come back, we go to trial. Essentially put us right back where we are now for trial.
All
So,
right.
but there's nothing today that
No.
you're planning on asking me to set aside. Okay, all right. And she's already signed it?
I do have a signed judgment here that I'll e-file when I get back to the office. My only
Correct.
question is, do you guys have 3-day forms that you have to fill out as well, or we go with just e-filing the judgment?
What's a 3-day form?
There used to be to advise the defendant of the rights under the 3-day rule.
Oh.
There used to be a form that
You know what?
had
We did used to have a form. I don't think so now.
I'm just making sure I don't need to do anything else but e-file
on
the
that
judgment.
judgment, just check it.
Yep, I did. I
Yeah,
checked both
and then
boxes.
I did it on the record, so there should be no question.
Wonderful.
Perfect. Okay, ma'am, so we'll get this judgment out to you as soon as he files it and it gets to me and I sign it, then we send it back. But you know your date to move,
Yeah, May
right?
10th.
Okay, all right, then you're all set for today.
Thank you.
Okay.
Thanks.
Yeah, you're done.
Mark, I need Jessica in here. I'm